Well, we are here today, as I said, because something very near to all of us and very dear to all of us, and that is our constitutional principles. It's become a tradition now that on September 17th we commemorate Constitution Day. So when we started talking about who would we like to have come to really talk to us about not only the U.S. Constitution, but the North Carolina Constitution as well, our good friend John Dinan, Wake Forest University professor, was the first name that came to mind. And I'm very happy to say that he accepted our invitation to be here. So he's going to be speaking with us today about some recent cases, some recent controversies as well concerning the U.S. Constitution and the North Carolina Constitution. He's going to be talking about ways that the outcome of the 2016 elections will influence interpretation of both of these documents and hold implications for individual rights, federalism, as well as separation of powers. Please welcome Professor of Politics and International Affairs at Wake Forest University, John Dinan. That on your, probably on your tie there, pretty high up. I won't take your presentation.
You're going to keep that? Uh-oh. Thanks very much, Donna, for that introduction, and thanks very much for this invitation to give the Constitution Day talk here. I appreciate having the opportunity to be back. It's always good to be here. Last weekend, I joined about 6,000 other political scientists at an annual convention. For most Americans, Labor Day is a time for barbecues, for beach trips. For political scientists, our tradition is to gather to talk politics, present papers, and hold panels. And so I was there in one panel in particular. This is fittingly enough. We were meeting in Philadelphia, I should say, birthplace of the U.S. Constitution. One of the panels focused on the Constitution and the 2016 presidential campaign. And the dominant theme to emerge from that panel was the absence of discussion about the Constitution in the 2016 presidential election campaign. And yet, at a number of other panels I attended at the same conference, presenters at those panels left little doubt that the 2016 election will have implications for the interpretation of the U.S. Constitution in important ways. In a way that leads to the suggestion that there should be more discussion about constitutional issues and constitutional implications of the election, whether by the candidates themselves, whether by debate moderators, or especially in forums such as this one among scholars, citizens, and public officials. So with that in mind, I plan to discuss today, as we commemorate Constitution Day 229 years after the week at which the Constitution emerged out of the Philadelphia Convention. I plan today to discuss the topics of what are the implications of the 2016 elections for the U.S. and North Carolina constitutions. I know that we're celebrating the U.S. Constitution Day, traditionally marks the federal constitution, but I want to bring the state constitution into that as well. In particular, let me set up my plan for the day. I plan to discuss in what particular areas is the U.S. Supreme Court currently evenly divided in such a way that a Republican or Democratic presidential victory would alter the prevailing interpretation of constitutional provisions. Now, to set up this, a little bit more setup, you might say, well, there's a lot of discussion about the Supreme Court appointment. Isn't that getting discussion in that way? Isn't there discussion about some particular cases that could come out differently? Agreed, but I hope to push the conversation in just a little bit different direction, perhaps a little bit further. I want to turn in particular to identify the key provisions in the U.S. Constitution whose interpretation is likely to change as a result of a presidential election victory for Democrats or Republicans. And I want to make a larger point about this. Given the difficulty of amending the U.S. Constitution, change in understanding the U.S. Constitution usually doesn't take place through formal amendments. There's only been 27 of them. And so how does change take place in our understanding of the U.S. Constitution? It takes place through changes in justices on the Supreme Court. And we've often heard, people can think back to the last 3 or 4 elections, maybe even back, and people always say, this election is a crucial one because it could change the balance of the Supreme Court. Well, that's turned out to be a bit of a crying wolf exercise if we look back. There's always these vacancies that are forecasted. and either they don't come through or they don't come through in ways that actually change the balance of the Supreme Court. That is, you get vacancies, and they're just filled by the similar parties as appointed those justices. But this is the real deal this time. It's really since 1968. We can go back half a century before you could truly say that actually an election has an opportunity to shift interpretations of the U.S. Constitution in important ways. And that's why so, because we actually have an actual vacancy. Justice Scalia's death has left us with a vacancy that will be filled by the winner of the presidential election, almost certainly. Well, and then just a little bit more of a setup. I also promised to spend some time identifying the implications of North Carolina elections for interpretation of the North Carolina Constitution. And I'll focus on two sets of 2016 elections in this part of the talk. One election is for one of the 7 members of the North Carolina Supreme Court, which is currently filled by 4 Republican-backed judges and 3 Democratic-backed judges. One Republican-backed judge is up for re-election and is being challenged by a Democratic-backed challenger. I'll look at several areas where a change in party control of the North Carolina Supreme Court could raise certain issues of the North Carolina Constitution for reinterpretation. And then I'll close by pointing out that actually state legislative elections have implications for the North Carolina Constitution. And again, here I want to make a bit of a broader point. State constitutions, their understanding doesn't just change because of judges change who interpret them, but it changes because actually formal amendments to the text are passed that actually change the actual language of the state constitution. And depending on the balance of power in terms of the state legislature, will determine which constitutional amendments you actually might see come out or not come out of the North Carolina legislature in future years. Enough of my preview. Let me get to it. Let me start with my various conclusions, and let me start with the promised discussion of what's the effect of the presidential election on the understanding of the U.S. Constitution. I want to stress here that my focus is on the implications of the presidential election for constitutional interpretation. In saying that, I'm leaving aside a number of non-constitutional questions that come before the U.S. Supreme Court. In fact, the vast majority of the 75 or 80 cases that the U.S. Supreme Court hears each year do not involve questions of constitutional interpretation. They involve questions of statutory interpretation. That is, you're not asking, is this or that law constitutional? It's a constitutional question. But you're asking, how should we interpret this law? How should we apply this law? Is the executive branch staying within its bounds as it applies this law? To give a few examples before I get to the constitutional questions, let me just kind of set out what are some of these non-constitutional statutory questions that one could mention. Well, the current dispute over transgender bathroom access that has given rise to decisions by judges concerning North Carolina's law, concerning a Virginia practice, both within the Fourth Circuit, decisions concerning a Texas case covered by the Fifth Circuit. All of these cases have not been decided on constitutional grounds. Now, various litigants have raised some constitutional issues. In his recent ruling, District Judge Schroeder agreed to receive more briefings, he said, if you want to bring arguments, further arguments about a due process challenge, a constitutional challenge, he would entertain them. But these cases have been decided entirely on statutory grounds. And the statutory grounds are whether Obama administration officials can interpret federal statutes, most of them dating from the 1960s and 1970s, that apply on their face to sex discrimination. Can they also be held to apply to gender identity? And then how would one interpret those in the case of bathroom access? So that's one constitutional type of, that's one non-constitutional type of question that, that I won't be discussing here, just to kind of set that aside. The same could be said, as of non-constitutional types of cases, recent litigation challenging the Obama administration's actions granting legal status and work permits to individuals in the country illegally. This, of course, was the subject of a recent Fifth Circuit court case brought by Texas and a number of other states. They challenged the Obama administration's executive actions. Led to a 4-4 deadlock tie in the Supreme Court this summer that left intact the Fifth Circuit ruling that prevented enforcement of the Obama administration's actions. My point here is this case, too, has been resolved entirely on statutory grounds. The question here is whether the Obama administration officials were acting properly pursuant to immigration statutes, more particularly whether they were following procedures set out in the Administrative Procedures Act when they took various actions. Now, one might say, and I would agree with this, that constitutional principles are at stake in these questions concerning the relationship between administrative agencies and congressional law. I wouldn't deny that. But if we talk about actually a case of constitutional interpretation, that was not what was at issue here. At least that's not how the case was decided. One final case that I won't be discussing before I get to the ones I will be. I'm spending a lot of time on these, but it's important to note. The final set of cases that I'll mention that have so far not been framed as constitutional questions, and this might be perhaps particularly surprising to us, these are the questions concerning claims by various religious groups or business owners with religious views, Hobby Lobby, Little Sisters of the Poor, raising claims that enforcing the Affordable Care Act in various ways, in particular requiring them to make access to contraceptives available and purchases. These cases that have been decided by the U.S. Supreme Court or in recent years have not, again, been decided by reference to the constitutional provision. You might think this would be a classic religious free exercise clause case, but actually that's not how they've come down. How have they been decided? How to apply a 1993 federal statute, the Religious Freedom Restoration Act. Does that protect owners of Hobby Lobby or Little Sisters of the Poor? So far it has. Well, as I say, it might seem as if I've spent a good deal of time discussing these non-constitutional cases, but I do so in part just to highlight much of the work of the U.S. Supreme Court is not involved constitutional interpretation. But let me get to my promise. What are the constitutional provisions that would be affected potentially by the outcome of the 2016 presidential election? I will focus on 4 leading areas where the court is currently divided, deadlocked, on the meaning of a constitutional provision, and where the outcome of the election would shift, likely, the interpretation. The most prominent effect of a Democratic presidential victory would be seen in the understanding of the First Amendment's free speech clause and its application to spending of money on elections. The 2016 Citizens United decision is the most prominent decision that interpreted the free speech clause with effects on campaign spending. But it's really just one of several recent campaign finance decisions where divisions between Republican and Democratic appointees on the court are clear and significant. The particular regulations at stake in these campaign finance cases vary. Questions come up. Can individuals and other groups spend money independently of the candidates? Another question comes up. Can an individual donate money directly to candidates, but adding all these up, can there be an absolute limit on how much an individual can give overall to all the candidates? Well, as I say, these types of particular questions, they vary in the cases that come before the U.S. Supreme Court. But the central question of constitutional interpretation has inevitably boiled down to the following. Should spending money on elections be considered protected speech under the First Amendment? An even more important question, how easy should it be, and on what grounds can government officials restrict election-related spending? Democratic appointed justices on the U.S. Supreme Court have been inclined to allow government restrictions on spending for a broad range of reasons. For instance, they'll say, if it's necessary to equalize political influence, restrictions might be allowed to be imposed. Republican appointed justices, by contrast, have tended to scrutinize very closely any restrictions on spending. Their view is that spending under the Free Speech Clause can only be restricted for the very limited purpose of combating corruption or the appearance thereof. When we consider constitutional clauses whose meaning is almost certainly on the ballot this year, not in a technical sense that it's on the ballot, but in a practical sense that it's on the ballot. The free speech clause would take top billing. In fact, the Democratic platform is explicitly committed to the appointment of justices who would overturn the Citizens United decision and the understanding of the free speech clause that was invoked in that decision. And this would almost certainly have the support of 4 other justices and thereby shift the meaning of the free speech clause away from its current understanding. Well, so that's a first constitutional provision that would be, its meaning is up for grabs depending on the outcome of this election. A second constitutional provision that could be said to be, in all practical purposes, on the ballot this year. The First Amendment's Religious Establishment Clause, and particularly its application to school choice programs. This debate has focused primarily around how do you interpret the Religious Establishment Clause in the U.S. Constitution? Should it be interpreted in a separationist fashion, favored by Democratic-appointed justices, or in an accommodationist fashion, favored by Republican-appointed justices? The separationist position says we could outlaw practices, that is, the U.S. Supreme Court could outlaw practices for a broad range of reasons. If a practice results in an excessive entanglement between the government and a religious organization, if a certain practice could be seen as endorsing religion by government, this would be the separationist provision and would lead to a lot of practices being struck down for violating that understanding of the Establishment Clause. The contrary position, the accommodationist position, views the Religious Establishment Clause as having a more limited effect of disallowing laws that coerce or compel persons to participate in religious observances. Be a much more narrower reason or type of laws or practices that would be struck down. Well, the accommodationist position hasn't prevailed in all recent cases, but it has had the upper hand in some key cases of recent note. Most recently, 2 years ago, a Town of Greece case permitted citizens to offer prayers before a local town meeting. Was an evidence of the accommodationist position prevailing. But probably the most important case in this area is a 2002 case, the Zellman case. Ohio had a school voucher program, and they allowed for public money to be used for students to attend the private schools of their choice. As it turned out, the vast majority of students using the Ohio school voucher program chose to attend religious private schools. Hence the question about whether or not the Religious Establishment Clause is at issue here. The accommodationist interpretation of the Religious Establishment Clause won out in the Ohio case, therefore allowing school choice programs to continue. But this position and this case would be particularly ripe for reconsideration depending on the presidential election outcome, and with implications for a number of states that have adopted similar school choice programs. In fact, I've suggested that Citizens United would probably be one of the first presidents overturned or severely limited by a Democratic majority on the court. The Zellman case applying to school choice would likely rank among the next precedents ripe for reconsideration. A third case, ranking right alongside the Religious Establishment Clause in terms of clauses in line for reconsideration, would be the right to keep and bear arms clause of the Second Amendment. Long-standing debate. Does this clause, should it be understood as guaranteeing an individual right, unconnected to whether or not individuals are participating in military service? Or does it really protect a collective right, the ability of the people to participate in the militia? That's been the debate about how to interpret the right to keep and bear arms clause of the Second Amendment. In 2 recent cases, in fact, this debate has never really been resolved or given a full hearing until the last decade, when in 2 cases, a 2008 case, the Heller case, and a 2010 case, the McDonald case, a 5-4 majority on the Supreme Court sided with the individual rights interpretation. Republican-appointed justices all supported the individual rights interpretation, Democratic-appointed justices taking a different position. I should say what was particularly interesting about the latter of these cases is that the majority and the leading dissent both focused on understanding the original meaning of the right to keep and bear arms clause. This is unusual, as I say. Usually when you have disputes on the court, it's because one side is saying, we want to know what the original meaning is, and the other side says, we want to know what the current meaning is in light of kind of current views. That was not the basis of the dispute in the McDonald case. Here you had both the majority and the leading dissent both saying, we want to understand the clause as it was intended by those who framed and ratified it. They just disagreed about what that understanding was. The next justice on the court would fill the vacant 9th seat, would either reaffirm the individual rights interpretation or could swing these possibly towards the collective right interpretation. Let me turn to a fourth constitutional clause, really a set of clauses here. These don't generally attract as much attention as the First or Second Amendment, but I'd say they're equally important, perhaps even more consequential than the First or Second Amendment. I'm speaking here of the commerce power of the U.S. Constitution. One of several clauses of the U.S. Constitution that sets out here are the powers that the federal government can undertake. Now, there's been a long-standing debate in this area, just as in the other areas, whether the Supreme Court should interpret the Commerce Clause and similar clauses, should interpret them in such a way as to essentially grant the federal government plenary power, or should they be understood with an understanding of enumerated powers in mind? If it's understood to be a plenary power, the federal government can undertake whatever powers it wants to as long as there's no explicit restrictions. The enumerated powers understanding would say if the federal government wants to undertake a certain task, it has to point, particularly in the Constitution, where it was authorized to undertake that task. From the mid-1930s to the mid-1990s, the court consistently sided with the plenary power interpretation. In fact, only twice during the 6-decade period did the Supreme Court strike down a federal act for exceeding the powers of Congress. Only twice in 6 decades. But beginning in the mid-1990s, a 5-justice majority on the court, all Republican appointees, began embracing the enumerated powers position and began striking down congressional acts as exceeding the boundaries of federal power, particularly the commerce power. For instance, the Gun-Free School Zones Act was struck down because they say we don't see any particular warrant in the Constitution for upholding this, and despite efforts to say that this is an exercise of the commerce power, that goes too far. Well, these questions, that's the background there, these questions, both the specific question about the reach of the commerce power and the broader question about whether the Constitution created a government of enumerated or plenary powers, they came to a head most recently in the 2012 Sebelius case, featuring a challenge to the Affordable Care Act, particularly the individual mandate provision. I'm going to leave out here many of the complexities of the Sebelius case. That'd be a Shaftesbury hour in itself if we do so, and probably a Shaftesbury of several. We could have a series on that. But I want to focus, just for this purpose, just on an often overlooked point about this case. All 5 Republican-appointed justices concluded that the commerce power could not be read in such a way as to support the individual mandate. And in doing so, they made clear that there are meaningful limits to the federal powers and that these limits should be enforced by the U.S. Supreme Court. The 4 Democratic-appointed justices did not see a barrier to the commerce power being interpreted in this fashion, and they did not see much of a role for the U.S. Supreme Court in enforcing these limitations. On this view, Congress ought generally to be given broad deference to use the tools necessary to address national problems. The punchline, the presidential election will determine, for all practical purposes, which of these views prevails going forward on a deadlocked court. Well, in focusing on these 4 constitutional provisions that I argue for all practical purposes are on the ballot this election, I'm also leaving aside several other cases with constitutional implications. So I started off by saying here's some of the non-constitutional cases I'm leaving aside. I've now presented what I take to be the 4 leading constitutional provisions whose meaning could shift depending on the outcome of the election. Let me say, I obviously haven't been comprehensive in my discussion of constitutional cases. There's others that I could discuss, and so let me close off this section. What am I leaving aside here in focusing as I have? Well, I would mention a case this spring. The court deadlocked 4-4 on whether the free speech clause requires workers who don't choose to join a public sector union can they be exempt from having to pay dues that would be used for collective bargaining purposes? Does the free speech clause give them an exemption from having to pay those dues, particular dues? This is the case, the Friedrichs case, that prompted Ohio Democratic Senate candidate Ted Strickland to remark last month that Justice Scalia's death, quote, happened at a good time, unquote, because it, quote, saved labor from a terrible decision. His point was that had Justice Scalia lived, the court would have certainly read the First Amendment as protecting workers from having to pay those dues in what would have been a break from precedent in that area. And presumably this is the reading of the First Amendment that would be given if the court got a new Republican justices, Republican-appointed justice. Strickland's remark was, of course, tasteless, but it was also accurate. And shorn of its tasteless features, it serves as a frank acknowledgement of the importance of the Supreme Court decision for interpretation of constitutional provisions. What else am I leaving aside by focusing on the cases that I have today? I'm also leaving aside cases where the court is not evenly split 4-4. That is, I've purposely focused on ones where the court is deadlocked, and so it's clear that a new justice would likely shift things one way or the other, certainly could shift things. But there are certain cases where the court is not currently split 4-4, and we have a case where a new justice wouldn't tip the scales or shift the majority, but would have the effect of either leading to an expanded Democratic majority or cutting into the size of the Democratic majority. Consider recent cases raising the question whether certain university affirmative action programs violate the 14th Amendment's Equal Protection Clause. The Supreme Court this term allowed these programs to proceed. Or consider questions about whether various abortion restrictions violate the 14th Amendment's Due Process Clause. The court this term disallowed certain abortion restrictions based on that clause. In each of these cases and several other cases, Justice Kennedy has already been voting with the Democratic appointed justices on the court. And so there's already 5 solid votes for these for interpreting the Constitution in this way. A 9th justice wouldn't shift the balance; it would just either enlarge or minimize the majority. And then finally, what am I leaving aside? I'm leaving aside various situations where litigants haven't even yet brought claims forward. They haven't even presented them to the court in recent years because they knew that there was very little chance of them succeeding. But if with a different justice on the court, particularly under a 5th Democratic appointed justice, we would very likely see a new set of claims being brought. There's no reason even to bring certain claims up until this point because there wasn't a chance of success. And so now one can envision various claims being brought. Most prominently here, we would probably see much more litigation challenging the death penalty as such in its consistency with the 8th Amendment's cruel and unusual punishment clause. Not just challenging the application of the death penalty to certain persons or offenses, there's been plenty of that, but actually challenging the death penalty as on its face unconstitutional under the cruel and unusual punishment clause. In each of these senses then, to wrap up my discussion of the U.S. Constitution, the implications of the presidential election for the understanding of U.S. constitutional provisions are even broader than what I've briefly sketched in the focus here, as I've just focused on the most prominent consequences. And of course, just one final thing, the consequences are even broader still if we take account of the many district and circuit court judges that the next president will have an opportunity to appoint, and who will issue interpretations of constitutional provisions that will, in a number of cases, not be reviewed by the U.S. Supreme Court. North Carolina is particularly alert to the importance of district and especially appellate judges and which president gets to appoint them in light of a series of recent rulings involving North Carolina laws that have the decisions that have broken entirely or nearly entirely along the lines of the party that appointed the judge. How about the North Carolina Constitution? I know the norm is at Constitution Day is to focus on the U.S. Constitution. I've spent most of my time doing so. That's what the day is commemorating after all. 229 years ago this week, the U.S. Constitution emerging out of the Philadelphia Convention. But I have made a point in these Constitution Day talks to turn our attention to state constitutions, in part because it's aspect of my own research, and in part I feel that it's useful. We don't pay enough attention to these often overlooked 50 state constitutions in the United States. And so let me turn to set out the possible consequences of the 2016 elections for the understanding of the North Carolina Constitution. One key election with implications along these lines would be state Supreme Court elections. It's a reminder of we select our judges differently at the federal level and the state level. Federal level, it's appointed. State level, elect them directly. North Carolina, as in many other states. And so the main election in North Carolina that can shift the understanding of the state constitution pits a Republican-backed incumbent against a Democratic-backed challenger. I won't say as much about areas where a shift in majority control of the North Carolina Supreme Court would result, or could likely result, in a shift in interpretation of the North Carolina Constitution. And it's not just because of time constraints. It's because the list is not actually that extensive for various reasons. For one thing, the state Supreme Court continues to decide many cases that come before the court by reference to the U.S. Constitution and U.S. constitutional provisions, and without regard to provisions of the North Carolina Constitution. It could decide them in various ways. Sometimes litigants will bring arguments that say, this violates the North Carolina Constitution, it violates the U.S. Constitution. But oftentimes the North Carolina Supreme Court continues to just rest its opinion with reference to the U.S. Constitution. For instance, we had a pair of decisions earlier this year. One decision struck down a cyberbullying law. Another decision struck down a law revoking teacher tenure. These decisions were grounded entirely in the U.S. Constitution and without regard to the North Carolina Constitution. The first case decided on the basis of the free speech clause of the U.S. Constitution, and the second case decided on the basis of the contracts clause of the U.S. Constitution. So in that sense, North Carolina elections wouldn't affect the interpretation of the North Carolina Constitution because the North Carolina Constitution wasn't at issue, or at least wasn't argued by the judges in those cases. Additionally, even in cases when the North Carolina Supreme Court does ground its decision in the North Carolina Constitution, many of its rulings are unanimous, or nearly so, in such a way that a one-judge shift wouldn't really shift things. Let me again give some recent examples. Questions concerning interpretation of property rights principles and whether they are violated by the state's MAP Act led to a unanimous decision earlier this year. And in a high-profile case, McCrory v. Berger. It's not quite a Bush v. Gore type of title, but it's for North Carolina, that's about as close as we get, a McCrory v. Berger case. Of course, that case concerned the power of the legislature to make appointments to commissions, some of which had some executive authority. What was the opinion? The court split 6-1, only one dissent here. So the interpretation of the North Carolina Constitution in this case wouldn't shift just by one election. But with that having been said, in certain areas the state Supreme Court is evenly divided or closely divided. And the understanding of the North Carolina Constitution would likely change depending on whether Democratic-backed judges gain a majority in the court in this year's election. The most prominent issue that I would point to involves interpretation of various education provisions as well as other provisions of the state constitution and their applicability to school choice programs. It's important to stress that school choice programs at the state and local level, they're vulnerable to two sets of challenges. They can be challenged for their consistency with the U.S. Constitution and could be struck down on those grounds, but they really have to run the gauntlet because they also can be struck down because they're seen as inconsistent with the state constitution. And in a number of states around the country, judges haven't read their state constitutions as providing higher barriers to application of school choice programs than the federal constitution. I mentioned earlier the U.S. Supreme Court said school choice programs can proceed at least as long as they're structured a certain way. But the state constitution can present an initial barrier. In North Carolina, an opportunity scholarship program was upheld last year in the face of various state constitutional challenges, but by a 4-3 vote along party lines. If I were making a list of North Carolina constitutional provisions ripe for reconsideration, depending on the 2016 election outcome, in this case the outcome of the 2016 state Supreme Court race, this case would be near the top of the list. This list, or this provision, at least, would be near the top of the list. Would other cases involving interpretation of the North Carolina Constitution come out differently depending on the outcome of the election? Oh, one could make a list here. Legislative redistricting plans have so far survived state Supreme Court scrutiny, even though they haven't always survived federal court scrutiny. Those could also run into challenge through the state Supreme Court under a differently constituted court. But let me close by discussing finally the way the meaning of the North Carolina Constitution is on the ballot this year in still another sense. In the sense that the outcome of state legislative elections will determine which amendments to the state constitution will appear on the ballot in coming years. I mentioned earlier, it's so difficult to change the U.S. Constitution. So pressures for change in the constitutional understandings at the federal level are usually channeled in efforts to change the composition of the court. If you're unhappy with the way the Constitution is being interpreted, it's so difficult to change it formally, so you push for different people to get on the judge. You push for a president to win the election and then to appoint a favorable justice. But at the state level, state constitutions are changed more easily, and therefore allows groups and officials who believe that a prevailing interpretation or understanding of the state constitution is out of line to respond by formally changing the North Carolina Constitution through the amendment process in a way that's technically possible at the federal level, but in practice it's quite rare. Well, North Carolina voters will not be considering any amendments to the North Carolina Constitution this year. But voters in 31 other states will be voting on a total of 91 constitutional amendments around the country, amendments to their state constitutions. It's about typical of an even number year. You might say, is that unusual? It's about what we usually expect for an even year election. This includes, just to give you a sample of this includes amendments that would add or extend certain rights. Indiana and Kansas voters will be voting on whether to add a right to hunt and fish in their state constitution, thereby joining 19 other states that have already passed such amendments. Oklahoma voters will be voting on whether to amend their state constitution to recognize a right to farm, joining 2 other states that already have passed such amendments. Voters in Montana will be considering whether to add a victim's rights provision, thereby joining 32 other states that have already done so. North Carolina passed such an amendment back in 1996. And voters in North and South Dakota, they already have a victims' rights provisions, but they're seeking to update and tighten and strengthen their victims' rights provisions through the constitutional amendment process. And then Oklahoma voters will be voting on an amendment to repeal religious establishment language in the Oklahoma Constitution that was invoked last year by the Oklahoma Supreme Court to order the removal of a 10 Commandments monument from the state capitol grounds. It was okay under the federal Constitution, but the Oklahoma Supreme Court said the Oklahoma Religious Establishment Clause is even stricter and orders the removal of them. Well, at the federal level, if you're unhappy with how a Supreme Court decision comes down, the only viable recourse really is hope for a different justices on the court or try to persuade the justices to change their mind. But at the state level, another recourse is possible. And this recourse is being taken by legislators and citizens in Oklahoma. They're seeking to change the language of the Constitution to prevent decisions that would order removal. Well, as I say, North Carolina is not among the states considering amendments this year. But that's not to say that North Carolina hasn't considered amendments in recent years. North Carolina Constitution amended on a semi-regular basis, most recently in 2014, where an amendment updated the jury trial clause to allow a waiver of a jury trial in non-capital cases. There was no waiting for a state Supreme Court to reinterpret a clause here in that sense. We'll just change the text of the document to update it. So this has been done in North Carolina. And other amendments are likely to be proposed in North Carolina in coming years. If Republicans retain a 3/5 majority or close to it in the state House and Senate, the first place to look for possible changes to the state constitution would be amendments that pass the state Senate but not the House this summer. One amendment would have lowered the maximum allowable income tax rate from 10% to 5.5%. Another amendment would have explicitly protected property rights against eminent domain takings. The North Carolina Constitution is the only state constitution in the country that does not have an explicit provision regarding property rights and eminent domain. It has been interpreted as protecting against eminent domain takings, but it stands alone in not having an explicit provision. Such a provision was proposed by the Senate this past term, but not agreed to by the House. Another amendment would join the 19 other states and add a hunting and fishing rights provision. The Senate passed that, but not the House. And then there are other amendments discussed in a serious fashion in the North Carolina legislature, such as establishing an independent legislative redistricting commission. In this case, though, if one was hoping for the passage of the first set of amendments I mentioned, hunting and fishing rights, tax break, one would hope for Republicans to increase or hold their current majorities. If one wanted to increase the possibility of seeing a legislative independent redistricting commission amendment passed, one would be looking to see Democratic numbers strengthen, particularly in the state Senate. So my point here in taking note of these amendments is to highlight yet another way that this year's elections will affect the meaning of the North Carolina Constitution, and that the elections will determine the precise partisan balance in the State House and Senate and reveal how much support there'll be for sending these and other amendments to voters. But in mentioning the role of amendments in the states, in North Carolina in particular, and taking note of some of the other states, I'm also aiming to make a larger point and highlight a difference in the way that constitutional change takes place at the federal and state level. I've alluded to this before, but let me just come back to this finally. At the federal level, changes in understanding of constitutional provisions take place entirely, almost entirely, through changes in the composition of the U.S. Supreme Court and who gets to interpret constitutional provisions. But at the state level, changes in constitutional understandings often take place through formal amendments to the state constitution, in which legislators and voters have a direct say. Let me conclude. It's always common for scholars, for analysts during election season to come before a group and to say, these are the issues that should really be talked about more in an election. I know that's a standard refrain. Somebody says, these issues are not getting the attention they should, and I urge them to get more attention, whether it be the size of the national debt, or the strength of the military, or the health of the economy, or the performance of public schools. Common refrain. These issues, or other issues, should be getting more attention than they're getting. And so in one sense, I could be seen today as merely echoing or joining a common refrain by making a call for more attention to the implications of the elections for the understanding of the U.S. Constitution, North Carolina Constitution. But I would maintain that this call for more attention to constitutional issues and implications might be seen as even more fundamental than some of the other potential issues that could be discussed in the election. And for that reason, the absence or virtual absence of discussion and attention to these constitutional issues might be seen as particularly notable and all the more regrettable. Thank you.
Kind of interesting, would you think that if the U.S. Constitution were easier to amend, maybe as easy as the North Carolina Constitution is, that maybe we would see a reverse and maybe change would come that way rather than changing to the justices?
I think it would. There's probably two things that account for the difference in the state approach and the federal approach. One is just the formal rules. It's pretty difficult to amend the federal constitution. It's not as difficult to amend the state constitution. But there's also a cultural approach to it. It's not just the rules are harder at the federal level. When people propose amendments, there's oftentimes a sense that it's not proper. We shouldn't do that. Suppose we had a slightly different set of rules at the federal level, or suppose even we just had a different understanding that sometimes that would be a proper way to undertake constitutional change. I think you could see constitutional change take place in that direction. I would say that, for instance, critics of the Citizens United decision had said in the aftermath actually proposed a formal amendment to the U.S. Constitution that would proceed, that would alter that. Some people reacted to that as if that was improper, and certainly some people said, I think it's a bad idea I think the free speech clause should not be changed. But another group of people said, well, you shouldn't really amend the Constitution for that. I thought that was an improper response. Improper is too strong. I had a different response. My response is, if you really think that the interpretation of the U.S. Constitution given by the U.S. Supreme Court is out of line, it's entirely appropriate to put before Congress and the people the opportunity, do you want to amend the Constitution? And I think that would perhaps be a different outcome and perhaps even a healthy result. Please.
You spent a lot of time on the First Amendment, and I find over the years that two elements of it, the freedom of religion and speech, has been either diminished or handcuffed. You never see anything on the freedom of press. And the freedom of the press today is now multifaceted.
Yeah.
It's so many media. even Google is media.
Yeah.
And you see things where Google has massaged searches. So you may not get everything you need, you're going to get what Google wants.
Yeah.
Is there any effort to, I guess, rein in the press as you see against free speech and freedom of religion?
It did make my list for several reasons. One, as you mentioned, just we haven't had those high-profile cases that have come up recently in the way that we have concerning other aspects of the First Amendment. But it's also the case that I don't think that we see the same clear division between Republican-appointed justices and Democratic-appointed justices on those issues. Put another way, there might be some more consensus on some of those questions than there is on some of these other issues.
We have a Democratic president and a Republican Senate in the federal level. What prospect would there be for the Senate to say, well, we're not going to approve of any of these nominees for judiciary positions unless they meet certain conditions that the Democratic president would refuse to meet? Do you see any prospect of that being a potential check on the Democratic president?
No, thank you for that. I gave a shorthand and really slightly too shorthand of a view when I said the outcome depends on the presidential election only. But as you rightly note, the president gets to nominate and the Senate has the power of confirmation. And so the real, if I really wanted to be fully descriptive, I would say the implications for the constitutional understanding of the presidential election and who controls the Senate in that way. What would we say? It's already, we've already seen over the course of the last year that the Senate is prepared to exercise its checking function and to not hold hearings on and not take a vote just because the president has made a nomination. That would be an exceedingly long time if we went several years further without a ninth justice, but it would not be unprecedented to go some length of time and not have a bench that is filled with all 9 members. We have seen that happen on various occasions in this sense. I would think the Senate would be entirely within its prerogatives if it, when a nomination is made, to determine whether that nominee is suitable and based on the criteria, and to either vote to confirm or not to confirm. We have seen Senates decide that a presidential nominee is not to their preference. Robert Bork was nominated by the president. It was not confirmed. So I think you could well expect to see some deliberation going on there. What form exactly that would take and what would be the outcome to be determined.
Roy, final question.
The way you described the changes in the federal court seems to undermine the purpose of the Constitution originally, which is to provide rule of law, which you described as rule of man. Maybe in that sense, it's actually easier to change the federal Constitution because it's just a group of 9, 8, whatever humans getting together and deciding what the Constitution is. So we've kind of moved away from the whole idea of rule of law at the constitutional level. Rule of men, what do you think of that?
I'm struck as I look at some of the cases I particularly focused on by the good faith nature of the disagreement among the justices. That these are justices who come to the question of how do we interpret the free speech clause as it applied to campaign spending. And I see one group that makes an argument, this is how it should be interpreted, the free speech clause. And then I see another group that has a very different interpretation of that. And this most came out, as I was emphasizing, in the interpretation of the Second Amendment, where when we had the McDonald case, the majority opinion and the principal dissent both said we're going to try to understand the original understanding of the right to keep and bear arms clause and its application. They came to different understandings of that. I take that to be rooted in the system and in the nature of conflicting interpretations of clauses. So if I saw cases, it'd be one thing if we saw a lack of a good faith understanding of trying to get at the meaning of the Constitution. I don't see us in that position. I see us in the position of sets of judges who are coming to the same text and sometimes even the same background to how that text gets written and coming to different conclusions, and the court reflects that.
Please join me